Good evening to the participants of the Advanced Intellectual Property SLW670. Karibu sana. Welcome to our class. Now, anyone can unmute and read what I posted on the screen. Participants, anyone can unmute and read what I posted on the screen. Yes, welcome to the students of the SLW670 online class on 2nd December 2022. And this is the intellectual property. And if you happen to see the course outline, it is clearly written the multiple legal framework, international, regional, national, the efficacy and the role of ARIPO. So now let us see the national one. What is the national intellectual property would be there? Then we can approach the regional, then we can go to the international. So like we follow that sequence. Now when you follow such a sequence, let us have a quick look into the intellectual property law in Tanzania and how it can be there, how the ownership and patent will work. So establishing the law and the ownership of the patents. The first bullet says the laws that regulates the patents. Second bullet, the rights and duties attached to the patent holdings. And the third bullet, how to apply for the patent in Tanzania. And ARIPO, that is ARIPO in the sense African Regional Intellectual Property Organization, that is acronym. So intellectual property refers to the legal rights which result from the intellectual creations in the industrial, scientific, literary, and artistic fields. So intellectual property covers the area of the industrial designs, industries, scientific achievements, scientific inventions, and literary and artistic fields. There is the books and novels and art, so on and so forth. Now let us see the intellectual property law aims at safeguarding the intellectual creatures, means inventors, and the other producers of the intellectual goods and services by granting them certain time-limited rights to own, and in so doing, control the use of the reference and the position of those creations. So, if any person created a new thing, if any person invented a new thing, and let the right will be given to him, and that is the reason that we will make it the patents, and depending upon the inventions, we can go for the trademarks, and we can go for the copyrights if it is the artistic work. So intellectual goods and services, by the granting them the certain time limit rights to own, and in so doing. So that you have some time limit would be there, those who invented a particular things, and control the use of the references and the position of those creations. These rights don't apply to the physical object in which the creation may be embodied, but instead to the intellectual creation. So only the intellectual creations will be protected, but not the other things are concerned. So intellectual property is divided into the two. These are all, number one, industrial property, which includes, in industrial property, there will come patents, trademarks, industrial designs. That is then we'll see the copyright. And when you see the copyright, it is for the artistic and literary work where you can use the International Instrument Berne Convention. Now let us throw light on the patents. It is imperative at this juncture to point out that this article will specifically focus around the subject and intellectual property procedure law governing the patents. So how it will be done in the Tanzania mainland? In Tanzania mainland, the laws that govern the patents are as follows. What are the governing law in the Tanzania mainland? Number one, the Patent within parentheses Registration Act of 1995, that is the Cap 217. Next, the patent regulation, there is a government notice 190 of the 1994 in the Tanzania mainland. When you go for the Zanzibar, the laws that govern the patents are patent decree, that is a Cap 157, and then other Cap 927 of the 1935, Section 5, 11 of the 1958, laws of Zanzibar. Then the patent rules schedules to degree number 1 of the 1930 in the laws of Zanzibar. So Zanzibar patent law is different than the Tanzania mainland is different. Definition of the patent is concerned. If you see the definition, the patent is an exclusive right for an invention. So if any invention would be there, it is having exclusive right. Who? The creator or the inventor having exclusive right under the patent following the particular law, which is based on mainland of Tanzania and based on the Zanzibar. It is a set of the exclusive rights granted by the sovereign state, and with the development of the laws and the concept registered by the multinational intellectual property organizations such as the WIPO and REPO. To an inventor or assignee for a limited period of time in exchange of the detailed public disclosure of an invention. An invention is a solution to a specific technological problem, is a product or the process. So either is the product or the process is concerned. So it is the international instrument as well as the Tanzania mainland laws and the Zanzibar laws decrees will be helpful to the inventor to protect his right for some certain period. So now let us see what is an invention. So when you see the invention, it is the trait that in order for one enjoy the exclusive recognition, right or protection, there must be an invention under Section 9 of the Patent Act, which will hereon forward refers to it as the Act. An invention means a solution to a specific problem in the field of the technology and may relate it to the product or the process. In the both the way, product or the process, it could be used for the invention. Thus, a patent is generally intended to cover the products or process that possess or contain a new functional or technical aspects. I repeat, a patent is generally intended to cover the products or the processes that possess or contain new functional or technical aspects. If the new functional technical aspect would be there, either with the process or the product, the intellectual property protection would be there. Patents are therefore the concern with the, for example, how things work and what they do, how they do so, what they are made of, or how they are made. So the vast majority of the patents are of incremental improvement is known technology. Thus, basically, patent law centers around the concept of novelty. There is a lack of anticipation. So, an inventive step or a lack of obviousness. In other words, not every invention is patentable unless it is new, could not be easily anticipated, and is industrially applicable. Specifically, Section 8 of the Act provides that an invention is patentable if it is new, involves an inventive step, and is industrially applicable. Then only we can say invention. So, who enjoy the right to protect? Who enjoy the right to patent? Naturally, the inventor. A patent for an invention is granted to the inventor, giving the inventor the right of a limited period to stop others from making it. He do have the right that no one should have to make such a type, the invention which he did it. Using or selling the inventions without the permission of the inventor. So, using or selling the invention without the permission of the inventor, it will be stopped over there. When a patent is granted, the invention becomes the property of the inventor. So once the patent is granted over there, then the property belongs to the inventor. And when the patent is granted, the invention becomes the property of the inventor, which he likes any other form of property or business. Sued can be brought and sold, and it is rented or hired because he will become the sole owner of the property. Patent are territorial rights in the sense that they are only recognized and enforced in the territory or country or jurisdiction under which they have been registered. So if once it is registered, yes, whatever the jurisdiction will be there, they will come and nobody should be disturbed. So that is the way, jurisdiction under which they have been registered. So wherever it is registered, all applicable law would be applied over there. So as per section 14, subsection 1 of the Act, the right to patent shall belong to an inventor. So the right is available only to the inventor. To be recognized as an inventor, one should apply to the granted a patent. So if he wants that his property, his invention could not be used by others, then immediately he should rush to the office of the patent and try to register it or patent it. A patent application may be a national patent application or an international application. So both the type of the application are then either national patent application or the international applications. If a country has ratified the international treaty, for instance, cooperation treaty, an application can lodge an individual. They can lodge an international application with a national or regional patent office or World Intellectual Property Organization, that is WIPO. What is the WIPO? Is it an acronym or is it an initialism? Participants, give me the answer. When you utter the word by word, letter by letter, then we can say it is a abbreviation. But the first type of the abbreviation it is. And it doesn't go with any full stop commas in between them. So World Intellectual Property Organization, WIPO, and thus seek the patent protection for his invention simultaneously in a large number of the countries. By that single application we can be used. See section 2B and 3 of the Harare Protocol, which is in Zimbabwe, on patent and industrial designs within the framework of the RIPO. So whatever the patent, either industrial design is concerned within the framework of the RIPO, then it will see that it will be patented. And the protocol on the patent and industrial designs with the framework of the RIPO as well as Article 7. Article 7 to 12 of the Washington International Patent Cooperation Treaty of 1970 are in the WIPO framework. So whichever it may be there, the people will tap the different international organizations agreements and they try to resolve the issue in amicable manner without disturbing the peace. Is it clear? Participants, you should have to speak. Okay. Section 18 of the Act provides for the grant of patent. How, according to the provision in the application, the applicant should prove that the invention is novel and it is a new and that it has never appeared anywhere in the world. That is, see the section 7 of the Act. According to section 7, subsection 2, the invention in this respect should not be, of course, the conditions are given, should not be, number 1, discoveries and mathematical theories. Number 2, plant and animal varieties or biological process other than the microbiological and the product of such process. Because now they are making the strict, that's why many herbs and seeds will not be exported, imported now. Third variety is the schemes or the rules or the methods of doing the business or performing the purely mineral acts. Purely mental acts. And the next point is methods for treatment of the human or the animal body, surgery or the therapy, diagnostic methods, but not produced for use in any of these methods. So this one should have to keep in the mind when you are going for further classes. Right of the owner of patent, within parentheses including the disposition and assignment. So if you happen to see this one, according to section 35 of the Act, the owner of the patent acquires the following rights, which, if done by anybody other than the owner, constitute an infringement. If anyone is other than the owner will be there, at that instance, we will see how it takes shape. So these are all, number one, if in respect to a product and the bullet is making, importing or offer for the sale, assignment, selling and using the product. The next point is bullet is stocking the products for the sale or for using. So when the rate is less, you can buy it and keep it in the store. When the rate is more, at that instance, you can sell the entire property, provided the property should not be perishable nature. So, if in respect of a processes, how it can be done? The use of that process, that is the first bullet. The second bullet is doing acts in one above in respect to the product obtained directly by a number of the process. So what the product are obtained directly by means of the processes. So it depends upon the variety, it depends upon the availability. Whether the things were not available over there, they naturally will import. When abundantly the things are available over there, when they're getting a good market, then we'll sell to the other country the product which are more produced in Tanzania. However, under section 68, subsection 1 and subsection 2 of the Act, a person showing a legitimate interest may request the court to declare that the performance of the certain act does not infringe the patent and the owner of licenses. Thus, it shall have the right to be defended in the proceedings, but such a declaration shall not be made if. What is the condition for the if? Participants, today you are very much silent. Please say, at least you are dumb. So, number one, the act to which the request is made are already the subject infringement proceedings. Number two, the person making the request is to prove that he has previously demanded from their owner of the second acknowledgement of the lawfulness the act referred to, and he refused or failed to reply in a reasonable time. So these are the two situations where we can say whether we are the legal heads of the deceased or not, forgetting the such a thing. Of course, it depends upon the only time factor would be there. So generally, is the 10 years to 20 years. If once they lapsed, then it is not patented. Everybody could have the right unless until it is renewed again. I mean, such inventions are renewed over there where the government has given the permission to not to use that property because it is invented by so and so X. How is a patent granted? So under the Tanzania law, a person who needs to secure patent for his or her invention has two options. What are they? The two options are, number one, by lodging an application with the register of the parents of the BRELA. It is an organization, BRELA, which will take care of the almost all of the intellectual property rights are concerned. So that is the thing which is made. And the next point which I would like to say is how is a patent granted under the Tanzanian law? A person who needs to secure patent for his or her invention has two questions. Number one, these are all by lodging an application with the register or register of the parents at the BRELA. Under the Patent Act, the inventor or any other person has the right over the invention files and an application for the registration of the patent with the Office of the Registrar of the Patents and the of the patents within parentheses sections 18(1) of the Act. So the said application should be made by filling the form number 2 as provided the procedures if they have given the chance to you to make the patent. According to section 18 of the Act, the application should contain the following particulars. What are the following particulars are needed when you want to register me or register any patent is? Participants, are you hearing me? There is no sound from the participants today. So according to section 18 of the Act, the application should contain the following particulars. Number 1, a title of the invention. Number 2, bullet, a description of the invention and stating the technical field under which the invention falls. So these are the criteria should be used. Now let us see the notes are concerned. The description should be in a clear language to be understood by a person with an average understanding in the field, such as they can work on the intervention being on the description. More elaborations such as the drawings should be made and should always, and the elaborations is that the drawing should be made and should also state what is eliminated, what is claimed in the maximum time of the study. So if you scroll down, you will find it by filing an application with the African Regional Intellectual Property Organization, IPRO. So here we will see what is the African Regional Intellectual Property Organization, that is called the ARIPO. African Regional Industrial Property Organization within parentheses ARIPO, which is an acronym because we will utter it the one word ARIPO. And based on Harare, which is there in Zimbabwe, is empowered by the Harare Protocol because it is held in the Harare on patents and industrial designs to grant the patents and to register the utility model and industrial design of half of the contracting states. The application, the grant of the patent may be filed either directly with the ARIPO office or with the industrial property office of the contracting state. So the application is subject to payment of the personal loss. Suppose if it is given the favor of the inventor, after some time the rights will be forfeited. So an applicant may be represented by an attorney or agent or legal practitioner and who has the right to represent applications before the industrial property office of any contracting states. So now if you go a bit further, an applicant may be represented by an attorney or agent or a legal practitioner who has the right to represent application before the industrial property office of any contracting state. I repeat this paragraph. Yes. An applicant may be represented by an authority. Then he is an agent and a recognized practitioner and who has the right to represent applicants before the industrial property office of any contracting state. When an application is filed directly with the ARIPO office by the applicant, ordinary residence or a principal place of business is not situated in the host country of the offices, or an application filed by the industrial property offices for combating the states by an applicant whose ordinary residence or comments, and there are comments also comes over there regarding this RIPO. So the applicant should be represented by an agent also there. Upon the receipt of an application by the contracting state, the industrial property office must, within the period of the 1 month after the filing of an application, transmit the application to the RIPO office. They will transfer by following certain norms. So that is about the RIPO office. Then following information and documents are required. To whom it is required? Naturally, it is IT. So the following information of documents are required. Number one, full particulars of the applicant. Yes, it should be needed when you want to upload in the online. Power of the attorney, prescribed form simply steadily, and you have to take the power of the attorney and you have to write it, and that will be equally valid. The specification, third bullet is specification, including the claims, drawings, and abstracts in English. That is the third bullet. And the fourth bullet is indications of the contracting states to be designated. And the last one, yes, but one, an assessment claimant if the applicant is that is necessary. The certified copy of the priority of the document if priority is claimed. Then if these documents are required, so all documents must be in English. However, it is possible to obtain the filing date of the RIPO with the specification and claims and drawing in a foreign language, provided the English translation of file without any delay. So a patent granted by the virtue of the protocol on patent and industrial designs within the framework of African Regional Industrial Property Organization, that is the Harare Protocol, 1982, in respect of which the Union Republic of Tanzania is designated as a state and have the same effect in Tanzania and Zanzibar. And Zanzibar, and its patent was granted under the local patent legislation. If the local patent office communicates to RIPO, the regional office indicating its objection to grant or patent. The grant by the RIPO has no effect on the United Republic of Tanzania. The reason is, yes, it has to be effective in the United Nations Republic of Tanzania until the addition is made in accordance with the provision of the Harare Protocol, which is held at Zimbabwe. So now the time is near approaching to a certain extent, but till it will stop, let me continue your class. Participants, are you hearing me? Participants. So what is the duration under which the patent production operates? Means time. In Tanzania, specifically under Section 38, subsection 1 of the Act, a patent is protected for 10 years from the date of grant. Furthermore, under Section 38, subsection 2, the owner or the license of the patent may request for an extension of the term of the patent for another 5 years, provided that the request have been made not more than 12 months and not less than 1 month before the expiration of the patent. So, RIPO protocol provides that the duration of the patent in each member country will be 20 years as required by the WTO and TRIPS. So now the present position is the 20 years. However, the national legislation in some ARIPO members countries have not amended to give the effect to this provision, and thus in countries like Tanzania, where the national provides, yeah, where the national law provides for the duration to be for the different terms, then the position becomes confusing. So hence the position in Tanzania being a dualistic state, that is presupposes an international law to be incorporated in the domestic law if the international law has to be the effective, or the law of the land is very kind enough and the law of the state prevails, and until the incorporation of the ARIPO, position is complete. So before the ARIPO is, then naturally these world fi- the world inventors have a right to protect his own property and their rights also. So if you see the further patent infringement and remedies, as per section 65 of the Act, a person infringes a patent by making what? Using or offering to sell or selling or imposing in any patented invention without the owner's authority during the term of the patent. So a person aggrieved by the infringement of the patent may institute a suit at High Court as stipulated by Section 66 of the Act. The court is mandated to grant the following relief for infringement if infringement is proven as per Section 66 of the Act. Now let us see with the conditions. An injunction to prevent the infringement or to prohibit the presentation. And number two, damages and any other remedies. Number one, an injunction to prevent the infringement or to prohibit the continuation. And the second bullet is damages and any other remedies. These are the things we would like to cover in this today's class. And tomorrow class, of course, today I'm going to take one session, and thus if and I don't believe that why the students are not present. Only the three were there, but three also I could not see them, whether they have the problem of Matandao or problem of they themselves only. So the next class, I told you now that I am going to make the second approach of the law existed in India. So if you happen to see here, we'll come across somewhere. Yeah. So why it is coming in this manner? That doesn't matter. Let me open like this. Where it is gone? No, it's not gone. Yeah. So if you happen to see the syllabus, it is the international, regional, and national, the efficacy and the role of ARIPO. But when you read it, the first part we read it today class, and let us see how far we can make it out to read tomorrow, means in the sense next class is concerned. So with this, I would like to stop my today's class, and tomorrow I will see the next class, the second aspect of the intellectual property in Tanzania. That I would like to teach. So by this, I would like to stop today for this session. Thank you very much for your patience listening. Mungu akubariki na kukulinda. And meeting end of the meeting.
Mungu ibariki Afrika.